I think is the best way. Someone else has just come into the waiting room. That's good timing. Excellent. Okay. Great. So now we are in business. Great. So what we're going to do this morning is I'm going to present to you the whole of intellectual property, all the different aspects of IP. Just to kind of be very clear from the outset, this is not legal advice formally per se. We'll touch on some legal issues as we go through. I'm going to flag up with you where it may be appropriate to speak to a lawyer if and when that might be the case, and the sorts of charges they might have, and we'll talk a little about what they might charge, but also what you can do yourself where you can, and the sorts of research we can help you with as well around intellectual property. I'm going to be flagging up some organizations along the way that could be helpful to you to support you on IP. So just to kind of get us going, what is it that we're actually talking about when we're talking about IP? So intellectual property is, at its most simplest, it's protection for creativity and innovation. It is something that's founded in law. There have been many acts of parliament over the years. The current sort of primary legislation we're working under is the Copyright Designs and Patent Act for 1988. Don't need to worry about that. Don't even need to read it. But what I'll be talking about today are all things which are sort of based on this current act of parliament with some amendments to it over the last few years. But everything is derived legally from that. But what we're going to be doing today is I'm going to be giving you the practical, what you need to know about IP, where you can apply it to your own business, your own, if you're starting a business, no matter what that idea might be, where intellectual property might be able to help you with that, or if you're an established business, what you need to know to protect your IP and make money from it at the end of the day. So when we're talking about IP, we're actually talking about property. So when I say IP is creations of the mind, it protects creativity and innovation, we're actually talking about something very tangible. So a lot of people ask, can I protect this business idea, this idea I have for a business? It's a common question that we have. And the simple answer to that is no, you can't. You can actually only protect actual expressions of that business, so tangible things. So that might be, let's say, the trademark or the business name that the business is known as. It might be the product that the business creates. It might be things that you produce in the course of running your business. So tangible things that we can see expressed in some way. It might be an invention, for example, which might be generating revenue for the business. All of these things are things that are tangible. So intellectual property doesn't protect abstract things like concepts, it protects real grounded things. I kind of emphasize this point because it's really important to have a grasp of that early on. And then everything else that I'm kind of presenting to you will kind of make sense and flow from that very important principle. So what are we actually talking about when we're talking about intellectual property? I like to liken it to different types of IP, are different members of the family. So depending on what that expression is that you're creating, what that actual thing is, one of the members of the intellectual property family will be used to potentially protect it and for you to commercialize it as well. So examples. If you have an invention, something new that works, has a working function to it, or potentially a process, this can or may well be, if it's novel and not been done before, be protected by a patent. That's one of the members of the IP family that can be used to protect an invention. Let's say you have a really cool brand that you have. It might be an image that your business is recognized with. It could be a business name, which could be a trademark as well as a logo. This is protected by another form of intellectual property called trademarks. It's another form of property. Designs, let's say you have a great looking product and it's famous for its look and appearance. You may want to look at getting a design protection for that. Let's say you are producing content one way or another. Maybe it's reports for people, maybe it's designs, drawings, architectural drawings. Maybe you're writing blogs, you're writing a book, you're a creative, you're creating music. Many different types of creative expressions are protected through copyright. So generally it's artistic works, although it does cover software and other works as well. More on that as we go through. So it's another member of the IP family that you can use. Then we have something else called, I sort of bracket them together, trade secrets and know-how. So trade secrets protect how things are done in a business, special techniques, processes, methods. Know-how is sort of practical knowledge that you have that'll give you a potential advantage over other people, other competitors, other businesses. So these are sorts of things, the secrets, if you like, in the business that give you an advantage that you you certainly want to keep secret to yourself, and that your competitors, you wouldn't want them to know. So we can call those trade secrets and know-how. So altogether, 6 members of the intellectual property family, and they all relate to whatever tangible expression the business is creating. Just one other footnote to that, we can divide the family into 2, into registered rights and unregistered. What do I mean by that? So for some of these, patents, trademarks, designs, you register your new invention, your new trademark, your design with the Intellectual Property Office. Here they are here. There's a process around filing for protection, and it varies depending on what it is. I'll go into more details around that in due course, but just so you know that is what we call a registered right. There are other rights which are unregistered, and they're automatic rights. So copyright is amongst them, trade secrets, know-how as well. More on that later when I get to those themselves. So always good to at this stage, as you're starting out, to be aware that for some forms of IP, there are costs involved with registering, quite significant costs if it's a patent, less so for trademarks and designs, and no costs for the unregistered rights, potentially. Do bear in mind that as you hopefully grow your business and you become known, you may have to defend your IP at some point in the future as well, because there's a chance that you may have other people trying to take or trade on your name or take your content or whatever without your permissions. So in that instance, you'll certainly want to be able to defend your intellectual property rights. Now, unfortunately, we can't call up the IP police and get them to step in and sort out the problem. It's all done through legal recourse, as it were. So that's why if you're going to object to someone using your content or your invention or whatever, you will need to go through solicitors, and there'll be fees, of course, involved with that. So at this very early stage, do think about putting some money aside, hopefully as you're able to grow, to defending your intellectual property. In the same way that you might put money aside for a marketing budget for your operations, for the day-to-day running of the business, just something to be aware of. Now, the property and the intellectual property side of things is actually a really important point. Do see the things that you're creating, your trademarks, your designs, the content you're producing, do see them as your property. I think it's really helpful to see it along those terms, because as your business grows, your business acquires more value, and your intellectual property becomes a really important asset in the business. So as the business grows, the asset increases in value. And if at any point in the future you decide to sell your business, or maybe sell your intellectual property even, or license it out to other people, you can see it as something that you own, as property. And I liken it to owning or buying a house. So you can, let's say you're lucky enough to buy a piece of land, and you build a house from scratch. You own the land, you own the house, you've completed the house. You can decide to live in it. Over the years, the house will increase in value, and then at some point you might want to sell the house. You can give your house to your children. If you pass away, you can hand that on to them. You can also rent out your house, and that's the same with intellectual property. You can effectively license out your property to other people in exchange for a license fee or a royalty or whatever. So do see the things that you own in the business that you create, the intellectual property, as assets, because they will contribute to the overall value of the business. Case in point here on the screen, I use the example of Coca-Cola. Now, I think you'd be a brave person to try and put a value on the trademark of Coca-Cola. That trademark is well over 100 years. It's a registered trademark, or in all countries all around the world. In many ways, that famous iconographic logo, the lettering as well, that represents the product, and it represents the company as a whole. And it would be worth, would it be billions? Potentially hundreds of millions for sure. That trademark, how could you even now put a value on it? Because if you were to sell that trademark, you're essentially selling the company. So it's of huge value. But you don't have to be a Coca-Cola. You can be a good sized, small, medium sized business with a really good reputation, with a small number of clients. That brand association, that trademark, which represents the brand, in some ways represents the value of the business and the reputation and the work that you've done. So super important. And that's something as simple as registering a trademark, which we'll go into in due course. So the property has value. So to continue on with the example here, this kind of neatly illustrates, I think, the 6 different members of the family. So we've mentioned here the trademarks. We can mention here the registered design aspect here, and that is the Coca-Cola bottle just here. That is actually a registered design. That was now over 100 years ago. That was registered around about 1916. It was one of the very early examples of design and packaging. And we can recognize it for what it is. If we're to remove that Coca-Cola logo from the bottle, we would recognize it as, just by the shape of it, it's that classic design. The bottle itself, it represents the brand, the company, the product. So a very early example of a really good piece of registered design is the bottle there. And another example, perhaps lesser known, is the ring pull opening on the can here. And there's actually a patent on that. That was a new invention. The sort of ring pull opening on a can. That invention actually goes back to, I think, 1966, the late 60s, by an inventor. It was patented, a brilliant invention, and he was able to then license that invention to some of the big drinks manufacturers, and now, of course, that patent is expired. Anybody can use it, but at that time in the late 60s, that was a brilliant new invention for sealing fizzy drinks in a can. It solved a real problem. How do you keep the drinks in a storage container, carbonated and ready to drink? So a great invention. And so the companies, the drinks manufacturers, would have had to have paid or get a royalty from the inventor to use it. Over here on the right is an example of a very old piece of advertising. This is one of the very early, I think it's from the 1920s or 30s, advertisement for Coke. So the company owns the copyright to that. It's a useful thing. They can reuse that copyright in, let's say, campaigns, particularly if they have a celebration or an anniversary. They can reuse the stuff. They can, of course, merchandise, all of this older vintage material, fridge magnets, t-shirts, you name it. There is still value in these old copyrighted assets that can be reused. So yeah, all part of the existing copyright that the company owns. And of course, Coca-Cola is famous, world famous, for its supposed secret recipe, which is, of course, unknown to most people apart from the executive team in the company. Now, it used to be under a lock and key in a safe in a bank in Atlanta, Georgia. It's now, I've been told, in the Coca-Cola Museum in Atlanta. Again, the safe on public display, a great attraction, I think. But it's a good example of a trade secret. We don't know what the recipe is, and it's kept secret all of these years. Of course, it hasn't stopped people trying to work it out and reverse engineer the drinking of, and it's a matter of opinion as to how successful that's been. If you think of Coca-Cola's other major competitors, Pepsi and many other smaller brands that have tried to do similar things, not quite the same, arguably. That's an aside. The point here is that it's a trade secret, kept a trade secret, but also, I would say, a very smart piece of marketing and branding. To have a little bit of mystique around the product is no bad thing either. And lastly, just to mention that last member of the IP family, the know-how aspect to the company. So the company has now been trading well over 100 years. That's 100 years of experience. The company can afford to buy in the best expertise in its marketing and its sales operations and its logistics. All of these aspects to running a global company that it is. It can buy the best and the brightest of talent, and basically there will be information, commercially sensitive information, supply chains, pricing information, local marketing information, because the brand has such a worldwide reach. The sum total of that knowledge is incredibly valuable. In fact, the company exists on this, and this is know-how which is kept in the company over the years and acquired. Why I'm emphasizing this point is from a small business point of view. I would encourage you to think or reflect a little. If you're starting out, what do I know that perhaps might give me an advantage as well? What know-how do I have? Maybe it's something that I can, maybe it's a good network. Maybe I have some good partnerships. Maybe I know how to sell really well or something. Maybe I've got a talent, or I know an industry really well, better than other people, or I can, or I know how to get the product cheaper to people, or whatever that might be. That's know-how, and I think no matter what size of business you are, as you acquire know-how, you can potentially acquire an advantage, and that'll get you started as you grow. So that's the sort of preamble. That's the introduction to all the members of the intellectual property family. And I spend a little bit of time just on this in itself, because I think it's important, again, to get the foundations clear as to what it is we're dealing with. And now from here on in, I'm gonna fly through each member of the intellectual property family, and give you the sort of the headlines, what you need to know about each of these different forms of IP. So at the end of today, at the end of this morning, as we finish, you'll have a good understanding as to which members of the family might well apply to you if you're starting growing your business. So let's start off with patents. So patents protect new inventions, how they work or how they're made, and that's a really kind of important thing about patents, is that they must be new and not obvious. So it has to have some sort of inventive quality, which is new and never been done before. They should be better, cheaper, or different to anything else. And that the criterion of novelty is a really, really important one. It's quite a high bar to kind of jump over. So there are ways to kind of check to make sure that your potential invention is new. we can potentially help you with that, and your local services here, BIPC Kent, they can potentially refer you to ways that you can do searches for patents. Certainly here at the British Library, we can help you with that. So the point here is that the criteria of being new and non-obvious is a really important one. Otherwise, whatever your application will be for whatever you think your invention will be, it just simply won't be accepted by the Intellectual Property Office. Also, another point here really is that your invention, whatever that might be, really should be better or cheaper or different. It should meet or satisfy a commercial need. It's all very well to have a new invention, great thing, but will it actually be able to be commercialized? Because as we'll see, patenting is the most expensive and time-consuming way of getting protection, and it only applies to specific things like inventions. Another important aspect here is that patents are they're international, as with all other forms of intellectual property. There's always an international dynamic here. If you want to sell your invention overseas or trade overseas with it, it's important to realize that you will need to get patent protection in territories abroad, and that will increase your fees quite substantially. And another thing to be aware of is that if you just get your patent in the UK, it does mean, unfortunately, that someone in a different country, when they see your patent published, which it will be in due course, they could use that invention in their own territory. What they couldn't do is sell it back into your home territory where you've got protection. So it raises some pretty big questions around, where are the markets overseas for the invention? Where do you want to get it patented? So there are some other really important considerations around this process as well. The patent will not last forever. A patent is a state-granted monopoly for 20 years. So you get 20 years to monopolize that invention, to make money from it, and then effectively it becomes public domain. Anybody can use it and commercialize it after them. So if we look at an invention like the zip, it's in clothing everywhere all around the world. Over 100 years ago, during the First World War, that was a new invention, and there was a patent on the zip, and that lasted 20 years, and now it's public domain. Anybody can use it. Any fashion designer, any clothing manufacturer can use the technology of the zip. So whatever your invention is, you've got 20 years. And it may even be less commercially, because if you're in an area where there's a lot of innovation, it's possible you could create something new, and then someone can leapfrog you and create something even newer, if that makes sense. And so innovation occurs off the back of innovation. So again, that's another dynamic to be very aware of around your patent protection. So like all other forms of IP, as we know, your patent can be bought, sold, or licensed. Now, if you were to do it yourself, to file a patent application, you can see on the screen here, it looks fairly reasonable. £320, whatever, plus renewal fees and so forth. That's a little misleading, because this is the one form of IP where we really emphasize and encourage people to get professional legal help. Why do I say that? Because the statistics speak for themselves. The Intellectual Property Office have done this research. Only 1 in 20 DIY patent applicants, if you like, get their patent through to grant. 1 in 20 is not a high statistic. Everybody else uses the services of a patent attorney. Why? Because it's a very complicated thing to write a good patent application. It has to be written in legalese. You want your patent to be defendable over the long term. There's a jargon and a technical wording that goes around the application, which it just really requires just good insight and good advice, and be it as it may. So so realistically, if you were just to get UK protection for a patent, you'd be easily looking at £2,000 to £3,000, including legal fees. So yeah, something to really kind of think very carefully about, and you have to balance that with the commercial side of things. And then again, if you want to you want to get protection abroad, your fees are going to increase substantially. So to get the equivalent of a patent around the world, so applying in the different territories, and there are ways and means of doing that, shortcuts of doing that, you're easily looking at sort of 50, 60,000 pounds to get sort of what would be sort of effectively global protection. Big money. Now, there are tricks of the trade, if you like. So you can file your application here in the UK, and you have up to a year to file abroad. And let's say you file 1st of January UK, and then you file in European territories, US. You can do that within a year from the 1st of January. And they will backdate that application to the UK. We call it priority date. That's just a kind of trick of the trade, if you like. So you have a year's grace essentially to work out where you want to get protected in other countries abroad and your costs and so forth. So yeah, these are all important things to be mindful of. Yeah, so that's important. I thought I'll come back to the point I was going to think of. I've just forgotten what I was going to say, but I'll come back to that in a moment. The other thing about patents is really important is that you keep your invention completely confidential, that you don't share the details of what it is to anybody. If you do, it's highly advisable you use something called non-disclosure agreements, NDAs. That means that you sort of have this legal protection over the divulging of the idea. And you might want to use that if you want to work with a manufacturer, prototype developer, or something like that, where you need to kind of share aspects of your invention. Otherwise, do keep it under wraps, do keep it confidential until you file the application itself. I just remember what I was just going to say to you. So with patents, just be aware that it does take 2, 3, sometimes 4 years before the patent is finally granted. And during that process, it'll be published, it'll be open to opposition. So there is quite a procedure to getting it published and granted. But all through that process, you can withdraw your patent if you like, and you can kind of spread out the payments, as it were, over that time. But basically, if you're going to go down that road, you can get help from the lawyer and talk to the IPO, and you can see how the payments might be structured over that time period. So confidentiality, all of these things are very important. Also, be wary of invention promoters, people that will say they can promote your invention, take a lot of cash in doing that, and leave you with nothing. There are some good ones, there are a lot of bad ones. So better that you speak to independent advisors like us. And if you're going to speak to a lawyer, the opening slide, CIPA, Chartered Institute of Patent Attorneys, they're a professional body that oversees standards for patent attorneys. CIPA. I'm sure we can make these slides available to you after today. No problem with that. So I'll liaise with Ashley, and I'm sure we can get that to everybody. So I mentioned as well earlier on around doing something called prior art searching, so looking for existing patents to make sure your idea really is new and inventive, but not just for existing patents, just doing general searches online. If it's a particular industry, look through trade press for that industry. The British Library here, we can help you with doing that prior art search. We have a research service here that can help you as well. And the database that you use is called a SPASnet. It's free online. We run webinars as well on how to do patent searching for free. And I've got a boilerplate that I can send to anybody that kind of gives you sort of the steps that you should do around doing a very basic patent search. And that's all around the prior art searching side of things. So that's kind of patents in a nutshell. And thank you for persevering this far, because patents are by far the most complicated and difficult area of IP. It's the most costly and time consuming. Everything else, I think it's fair to say, is a lot clearer, perhaps until we get to copyright. But that's the heavy stuff out of the way. So let's move on now to trademarks. And I think this member of the IP family is one that I think perhaps many or most of us, or if not all of us, will potentially make the most of. So if you have a name for your business, this can get confusing because you may have the name of your company, which might be the registered name that you register with Companies House. That can be, let's call it the legal name. That legal name can be different from the brand that you trade under. So what we're really talking about is the brand here. I'm kind of using the word brand and trademarks sort of interchangeably. The trademark is the registered mark, the registered brand that you have. It's the trading mark, quite literally that. It's what you are known as you trade in the marketplace. And we are surrounded every day of the week by trademarks, and we don't even blink, we don't even think about it. If you walk down any supermarket aisle and you pick up any product off the shelf, if you look very carefully, you'll see probably a brand with an R in a circle, very small R in a circle. That means it's a registered trademark. And there are hundreds of thousands of registered trademarks in force at the moment, and you can join that crowd depending on the industry that you're in. So what does a trademark do? It distinguishes you from your competitors. It's your mark, if you like. It's the name, logo, slogan. It can be a shape, color, or sound even, but most often than not, it's the name and or the slogan. It can be both. The thing about a trademark is it has to be distinctive for the goods or services you're trading in. You can't be the same or similar to anybody else. You have to be distinctive from your competitors, and you can't give any false impression with your trademark. Now, like the other forms of IP, you register here in the UK, and if you're going to trade abroad, you should register your trademark in the countries you're trading in. And that's a process that we can share more information about perhaps after the webinar. Drop me an email, I can provide you some more detail. But long story short, you can file across the European territories, you can file for the US, Canada, wherever else. So it becomes, when a trademark is accepted, and that's a lot quicker process than here in the UK, 3 to 4 months to know whether or not you've got your trademark. Your trademark then becomes your property. You can sell it, license it out, and in theory, it can last forever, because with a trademark, you just simply renew it every 10 years, so long as you are actively using it. It's a very reasonable, I would suggest, form of IP. A paper application is £200. Doing it online is a bit cheaper, £170, plus extra fees for the categories that you register in, about £50. I'll talk about the categories in a moment. And you do that, of course, through the Intellectual Property Office. So the registered trademarks here, now often the question arises, can you have the same or similar trademark as someone else? And the answer to that is maybe. It is possible, but only in these circumstances. If the similar name is in a very different, we call a classification as someone else. In other words, a very different trading area. Here's the example on the screen you're seeing. So we have here Swan Car Rentals, Swan Iron, Swan Matches, the same name, Swan, but the brand owned by 3 different companies in very different classifications. One would be services to do with transport, the other would be electrical goods, and perhaps the matches would be something like household goods or something along those lines. Now, the point here is that when you file your trademark, there are just over 40 different classifications that you can file your trademark in. And the best thing is to find the right classification which best describes the area that you're trading in. And we call this the NICE, as in the city in France, NICE, the NICE classification system. And it's international. Every country uses it. It's universal. And so when you go to file your trademark, you have to choose the NICE class mark. And if you have the same or similar, but in a different mark, you can trade. If, however, you have a name which is the same or similar to someone in the existing class mark you want to file, and that's where you most likely have some issues. You may not get your trademark because of confusion. So there are things called unregistered rights. Here in the UK, we have that. In common law countries, that's generally the case. Not in Europe. You have this right in the US. And I'm sure you've seen this TM next to brands or company names or whatever. You may be wondering what that actually means. Well, it's an informal unregistered right. And sort of the joke amongst lawyers is that TM kind of means totally meaningless. It's not totally meaningless, but it's not as strong as having a registered mark. I could today create a brand, put TM next to it, so long as I'm absolutely sure as I can that I'm not infringing anyone else's brand, their name, their product name, or their service name. I can put TM next to that brand and trade with it and become my trading mark. If someone infringes my trademark, I have to potentially go through some costly legal advice and proof to say that I got that brand before they did. Whereas the registered trademark, if I create a brand today and I register it and it gets accepted, I'm legally entitled to put R in a circle next to that name, and it's much easier to shut down anybody that imitates my brand. It's a simple cease and desist letter from a lawyer that usually ends the matter quite quickly because you have a registered mark, usually. So we've got two examples here. Now, Google, they are massive. They at the time, or they haven't registered their trademark. They don't need to. They can defend it quite adequately with the resources they have. McDonald's, on the other hand, have registered their mark. They would because it's a franchise. They need to own all the property. They need to own the name and manage that name and the service around it very carefully. So two different examples there. So something to be very aware of when you file your trademark is these are the reasons why your application may be rejected. Three of them are quite obvious. Anything obscene, blasphemous, causing offense, not allowed. Names of pictures of famous people or characters, well, that would be a copyright infringement for a start, not allowed. Using international symbols such as flags, Olympic rings, Red Cross, obvious reasons, that wouldn't be allowed because these other organizations own these things. Here's one that most people get caught up on. Wording that describes their service or their product. So, in other words, descriptiveness. If your trademark is too descriptive, it will not be allowed. So, for example, if I try and register the trademark tasty cakes, that I'm sure that would be rejected because it's too descriptive. And at the end of the day, what right have I as a cake maker to own the phrase tasty cakes? They wouldn't allow it, too descriptive. If I were to say put another word or name in that description, say Jerry's Tasty Cakes, putting in the name Jerry adds an element of distinctiveness to that phrase, a much higher chance that will be accepted because there is the element of distinctiveness and it's not descriptive. So something to be very aware of when you file for your trademark, the originality of the name and also the design, if you go for a logo as well, is very, very important, and that it must not be descriptive in any sense. So like patents, before you register your patent, very advisable that you make sure it doesn't already exist or there isn't some other similarity in the same class mark. And this is where we have patent databases. It's fairly easy to use, I'd say. On the .gov website, the IPO, Intellectual Property Office, have this database freely available. If you were to even Google trademark search trademark UK, I think it will come up as the top or second search result. You can click in, type in the names. We can guide you around that here as well, around how that might be done. We run webinars as well on doing trademark searches. And then you can search by the name, that's the lettering, the word, and also by shapes, to cover off the visual element if it's going to be a logo as well. Because your trademark can be either a word or a logo, or indeed both. Trademark can be both. Examples here, the Boots trademark, they have this famous lettering registered. I'd expect they would have BOOTS registered in the trading categories which they trade in. Pharmaceutical, retail, or whatever it is, the class mark is for that. Bacardi, another good example here. The name Bacardi is, of course, very distinctive. That is registered. The sequence of lettering, but also the bat logo there. If you don't see the Bacardi lettering, you know, if you're in a bar or whatever, and you see the logo in the dark in the distance, you know what the drink is. So there is a visual strength to that logo, but both of which are registered as trademarks, both the logo and the lettering itself. Some logos are become so distinctive and recognizable that they are of huge value in and of themselves. The Superman logo here, so Marvel own the logo, the rights to that. Who owns Marvel? That's a good question. I need to look into that. Who, if they own it themselves now, whether they've sold, Marvel sold their rights to someone else, I'm not sure what they said is. Doesn't matter. That's an aside. The point is that that trademark is of an incredible value because you have the licensing power to license that out to thousands of merchandisers that make t-shirts, badges, toys, you know, everything Superman related. That owning that trademark is it's a money spinner. Seriously is. So it's the power of the logo, and once it becomes recognized and famous and synonymous, it's yeah, very, very, very powerful piece of property. Emphasizing that point again. So making good progress. The next few registered design I'll cover quite quickly. Spend a little bit more time on copyright just because that is a little bit more complicated, and then we'll wrap up with secrets and know-how, which we can quickly cover off, and then we'll open it up for questions. So not long to go. Thank you for persevering so far. I hope you're finding it useful. Please start to think of some questions. You can put your audio on at the end if you wish, or if you want to put some questions in the Q&A in the chat. Either way is fine with me. I'll look forward to seeing or hearing from you at the end of the day. So moving on to registered designs. This is, again, a particular type of registered protection for a particular type of expression, meaning designs, and it protects the look or object or item. No surprise here. What makes a registered design is something that is new, unique, never been seen before, and you can register your designs like trademarks, patents in countries, regions. It's property, can be bought, sold, licensed. Doesn't last forever, mind you. 25-year standard. The cost of design is very reasonable, I would argue. So there are real strengths to registered design. However, there are weaknesses. So you have to be very, very savvy around your application for a design, because the application, the drawings that you submit, I would recommend just doing your drawings in outline, keeping it as broad as you can get away with, so you get that design protection on the outline. Because what happens is you might design, here's an example on the screen, a shoe, right? You get that registered, becomes your design. But what's to stop someone from taking that shoe and, you know, changing the heel shape a little bit, changing the point of the shoe, putting their own take on it, and it might become something new and innovative off the back of your registered design. So it's very easy to alter and to change existing designs and get something new, and have that registered under your name, your business name. So even though they're quite affordable and sometimes quite a good option to go for, they are also potential for some areas, for some designs, they can be changed and innovated and altered, and you won't get that protection in quite the same way that you might get for other things. So here are some examples of registered design. The Fender Stratocaster guitar, the registered design is on the tuning head there because it's recognized as being so distinctive. They want to protect that design. Some fashion items, not many, are registered design. That's not very common in the fashion industry because fashions change quite often, and there's lots of innovation and change every season. So having a design doesn't really make much sense. But sometimes there are fashion items that have longevity. I think here the Ray-Ban glasses, Doc Marten boots, for example, things like that which have a much longer life cycle to them. I certainly very worthwhile getting registered. Jewelry pieces, for example. I think particular products, toys are great examples. Quite often toys are registered designs. Interesting thing here, the Star Wars Stormtrooper helmet is a registered design. Surprisingly or not, the Shrek doll, the Shrek character is a registered design. You'll find interesting things popping up. So where designs can be mass produced at an industrial scale, they're more likely to be covered as registered designs. Furniture can sometimes be designed. Fascinating area. Design is a massive industry, and there is real value to it. And we're finding these days that the big tech companies, Apple, Samsung, they use registered design a lot. They'll push it as far as they can around what they can get away with in terms of their designs, because they are not just tech companies. Particularly for Apple, they really lead on their design innovations. So it's important, and it may well be an option for you. I would just add as well, I'm talking about products primarily, but also you can get some pretty nifty package design as well. Packaging can be registered design, and that can be very useful if there's something about the packaging that attracts people to your product. So anyways, quite straightforward. Again, file with the IPO. We do have separate webinars on doing searches for registered design. We can help you beyond today if that's a road you want to go down. Right, so moving right along, this area, copyright, is an absolutely fascinating area. I present the copyright webinar once a month here at the British Library, but I'm going to distill my 1 hour into about just under 10 minutes, all the things that you sort of the headlines that you should be aware of around copyright. I'll try and present them to you right here. So I tend to sort of consider copyright as the everything else bucket. So I've presented to you inventions, patents, trademarks, logos under trademarks, design under design, trade secrets, and pretty much everything else. More likely fits under copyright. So it's a very broad right. It's a little bit different to the others on a number of different levels. It's been around for a long time, as with some of the other IP rights, but it has evolved its own character, copyright. So there are some differences to it that are worth being very aware of. So when I say it's an automatic right, again, you don't register it. As soon as you create something, it becomes yours, becomes your property. So that as soon as I put the last full stop on my world-selling famous novel, that becomes my copyright. I can choose to sell my copyright to a publisher in exchange for royalties, but I have ownership of how I manage that work. Likewise, the photo I take, the web page I put together, the software that I finished, all of these things. So it's free and instant. Now, the types of things that can be copyrighted, I've mentioned a few already. Here's a list here of some more things, perhaps some surprises there. Architectural plans, radio broadcasts are copyrightable. Music, of course, in all its forms, live performances, you have to get permissions to perform live music, any kind of recording, broadcast, etc., etc. The notation on a music manuscript is copyright. Plays, of course, copyright. There are things around databases which are potentially come under copyright. There's a database right, which is similar but slightly different to copyright. The things that you're advertising, your marketing becomes your copyright. We've seen that example with Coke. Lots of examples. So here's the thing about it being automatic, and you don't have to register. So there's a quid pro quo with that. You don't register, but you do. You may at some point have to prove you own the work that you've created, and you created it when you did, because there's no one to stamp or register your novel, let's say. You need to somehow be able to prove that it belongs to you and you created it when you did. If someone else copies you, you want to be able to say, I got there first, and prove that you got there first. So number one tip, very easy thing to do. Just as a matter of habit, really, put C in a circle, your name or the company name, the year of when it was produced, on your web page, at the beginning of your work, the back of your photo or whatever that is, or have it watermarked in a digital file to make sure that make very clear it's your copyright. You then need to prove the date. So options here, you may, apparently you can file it with a bank. I've never known anyone do that. Certainly with a solicitor, you can file your manuscript, print off your photos, whatever. And they will stamp it as received. I'll archive it. That dating is established. It will become admissible evidence if there was ever a dispute with someone. There's the good old post your thing, your musical score, your USB recording of your original songs, your novel, post it to yourself, registered post, in a sealed envelope. Make sure that envelope can't be tampered with. Then you have that sort of date proof with the postal stamp. I've never known it to be actually put to the test, but nonetheless, it's one way of evidencing date. There are copyright services where you can apparently file your copyright online. These are private companies. I don't recommend them per se. I don't have an opinion about them, other than that they exist. Buyer beware on services like that, I would say. I will talk about one service I've recently come across which I think could be of interest to many of us, and that is Wipo Proof. Wipo being World Intellectual Property Organization. They now offer a digital timestamp service whereby you sort of pay about 18 Swiss francs or whatever, and you get your digital file effectively verified as being created on the date that it was, and that would be potentially admissible if there's any kind of dispute of anybody. That's called Wipo Proof, because evidencing digital content is actually quite tricky, because I can create a Word document, and the problem is that software can be easily manipulated. You can change dates and things with software. You want that external validation outside of a computer program that you created what you did. So that's another option for you, called Wipo Proof. You can Google that. But the point here, all being the same, you need to evidence you created what you did when you did. If you are using the services of other people, so freelancers that might take photos of your products, that might design your logo, and the other examples you can think of, where you're using freelancers, software developers, the default position in law is that they actually own the intellectual property. And you would need to ask them to assign to you the intellectual property of the logo or whatever it is that they're being commissioned to do for you. situation is in reverse if you are an employee. If you're a full-time employee, or even part-time, and what you're creating is in the course of your employment, your employer will own the intellectual property rights. So a very important distinction there. If you are a freelancer, please be aware you have the rights, you have the ownership over all of the work that you do for other people. Do ensure that you realize that, and you make that clear with your client, and likewise if you're a client and you commission work, do ask about that question around IP rights. The Innocent Smoothies logo with the halo, the sort of the quirky cartoon with the halo. In the early days, they had a freelance designer design that logo for them. When the brand got big and famous, the designer came back to them and said, "Hey, that's my design. Can I have a share of the cake?" And the designer was well within their rights to do that. They had to come to an agreement. It involved shares in the company or in other things. I'm not too sure on the exact details, but nonetheless, it was a fairly time-intensive and costly way of resolving what was a fundamental issue. They never had the IP assigned from the designer to the company. So please be aware of that as a potential issue. People quite rightly ask, what can I use of other people's content? It's a common question. We've all asked that ourselves at some point, I'm sure, in the various course of our day-to-day work or hobbies or whatever, or in our business. So there are very, very specific exceptions to copyright, and here they are. I'll go through each of them, and then we'll talk about the implications of that. So exceptions to copyright. You may use other people's content for non-commercial research or private study. That is, you're not reselling it, you're not reusing it. It's just, for your own private use for study. That is allowed for in the Act. Quoting for critique or review, that makes good sense, particularly if you're in journalism or in publishing. Quite often you need to quote other people just as part of the free flow of ideas. We need to have that. The world runs on information. We need to be able to critique, review other people, to quote other people. It's just part of the flow of things. But you can see that's a very specific example. If you were to quote more substantial aspects of someone else's work, you're then potentially moving into infringement. You are especially infringing if you are commercially benefiting from that more substantial use of other people's work. That's the rule of thumb. Making a copy for someone visually impaired, just for reasons of helping other people who maybe have a disability, that's an exception, as one would reasonably expect. And I think time shifting, so that again, it's sort of personal use, recordings, that kind of thing. Otherwise, you need to gain permissions to use other people's material. There is other alternative forms of copyright being created commons. They work as licenses. You can often use photographs on a Creative Commons platform, but it's still a license. And here's the other point around copyright. If you're the owner, the copyright owner, how you earn revenue from your license is that you have terms and conditions around the usage. You might get a royalty in return for licensing out the content. But that's how copyright is used by other people. So the point being, a Creative Commons license is just that. It's still a license. You are still entering into a copyright agreement with the creator, even though the terms and conditions of that agreement are actually very, very generous, meaning you can use it potentially depending for commercial use. But do look at the CC, the Creative Commons details of the license. It may be that you may need to credit the owner of the work or whatever else. So it's a good example of how licenses are common across all of copyright, even though they might be very generous or they might be restrictive, depending on the content and how it might be used. You as the owner, if you're creating content, you have a lot of rights over your work. You have a lot of say over how that work can be done and used. Open source is a similar principle, but for software where you're using source code. And if you're using open source, you just have to make that source code freely available to others. So copyright, again, it gives you a lot of rights. You have the right over copying, adapting, publishing, renting, performing, broadcasting. And copyright, again, to underline, is your property. So you can sell your rights. The Beatles is an interesting example. The Beatles assigned all of their songs very early in the 60s into a company. So all the intellectual property rights around their music was put into a company. It got interesting when that company was sold. They effectively sort of lost some control of their intellectual property rights, because that got sold on to, I think it was Columbia Records. They brought all of the copyright rights to their music, and then that got sold on to Sony, and then Michael Jackson got a share of that ownership, and then eventually the back catalogue got sold on, or Paul McCartney, Yoko Ono, bought the rights back off the Jackson estate. So you can see here how copyright as a thing, the actual products, and let's look at the music as a product. It's a rather awful thing to think of, but it is. It gets bought and sold and transferred between companies, and that's where copyright can get a little complicated. And the film industry is a fascinating area again, of where there are multiple layers of copyright and ownership and assignment, and you got screenplays and directors' rights and musical score and all of these different creatives. There are often quite complicated deals done, and legal agreements around copyright and ownership and assignment and all these sorts of things. Fascinating area. Time forbids me from going into any more detail for the moment, but perhaps you'll have some copyright questions for me soon. And just to wrap up, our last two members of the family, know-how and trade secrets. I've mentioned already how trade secrets mostly relate to things like recipes or manufacturing processes, definitely. How you keep something a trade secret is something you don't disclose. If you bring employees into your business who are privy to the secret, you have confidentiality clauses in their employment contracts. Or if not, you're doing a deal with a manufacturer, you have you have a confidentiality agreement between the two of you around what can be shared or not, what being the case. And the good thing is, with trade secrets, there is no expiry date. The expiry is the secret. So as long as you keep it secret, there is no expiry. And Coca-Cola is a good example of a secret recipe kept secret for over 100 years. Know-how, we know, I mentioned that. And again, just to underline, as a good thing to do is to think about the know-how that you have, the things that you know that might give you an early advantage in starting and growing your business. So that's wraps up our content here. Again, to flag up our site here, if you have any further email queries, rather, feel free to drop us an email, bipc@bl.uk. I'll put that in the chat box in a minute. IPO is a very important website. The Intellectual Property Office, they have excellent, I call plain English guides on all of these aspects of IP. We also have guides on our own Business and IP Centre website as well, the British Library. You're more than welcome to go into those, have a look at those. There's some good content, good advice there. So I now want to open up for questions, everybody. So feel free to put a question in the chat. And we can take it from there. Or if you want to ask your question out loud, I'm sure you can do so. Just unmute yourself, and I think we should be able to hear everybody from there. No questions? I'm going to stop the recording anyway. So let's